How much do you think you stole in cash?
In total, like in cash or in gift card? Are you
Cash.
talking?
In cash.
In cash? Like 4,000 or 4,500 once.
Okay. And then the gift cards was another?
Yeah, the gift card is like 4,000 or 4,000. Like in total for both, the max is like 8 or 9,000.
On June 25, 2024, the Palm Beach Sheriff's Office conducted a custodial interrogation at District 3 Detective Bureau.
Hello. What are you doing? Standing for me. See you in back. Under arrest. You got anything on you? Your phone? Where's your phone? I guess we should have taken your Walmart vest off before and handcuffs.
Yeah. So I think you can put it.
Do you have any locker or any other personal property here?
No, just my bag. It's in there.
Your bag?
How'd you get to work today?
Can we dance me?
What's in your backpack? Anything crazy?
Go ahead.
Nothing crazy? Okay.
You
Do
got
you need a key to
me
get out?
GM grab and go.
It's just in
I want to tour the front end.
It's in the break room?
Yes,
What does it
Okay,
look
no
like?
problem.
it's just a black bag. It's in the second closet.
Second closet? Second
The
closet? What
second.
color?
It's a black bag.
Is there anything on it? Any design? Any?
No, it's just a black bag.
Big idea.
Enough for you? No, she's on. Close. We'll drop the hood.
So in your pockets?
No, that's the
It's just this?
Yeah.
No, no, you do a tempo test.
Just one shake. Where's your phone?
And then his necklaces.
Alright, so lay those on.
Put them in his backpack. Alrighty.
Maybe we can.
Walmart quickly uncovered the scheme. An 18-year-old employee had been scanning items twice, issuing fake returns, and pocketing $9,000 in cash and gift cards. Once the fraud was detected, officers arrested him on the spot, ending his short-lived month-long job in disgrace. At the precinct, detectives presented the overwhelming evidence, and with no way out, he confessed. What he saw as an easy payday had instead led straight to serious legal consequences.
I'm gonna read you your Miranda warnings, okay? Are you familiar with what those are?
Yeah, like
Alright. Okay. Because I have some questions for you. I'm Detective Schultz. I'm helping my partner,
Can I
Detective
move
Bates.
the chair?
You want to what?
Can I move the chair?
Move the chair? Yeah, of course. Here, can you move it? I can move it for you. You got it? Okay. Okay. All right. This is going to be a sworn recorded interview. Reference PBSO case 24073-287. Today is June 25th, 2024. It is Tuesday. It's approximately 14:39 hours. This interview is being conducted at District 3 Detective Bureau. I am Detective Schultz, ID 30545. Present with me today, please state your full name.
Carlos.
This is wearing all black clothing today. Carlos, do you speak English?
Yes, ma'am.
Okay. Are you under the influence of any medications that would affect your ability to tell the truth or understand the questions that I'm going to ask you?
No, ma'am.
Okay. Do you have any mental conditions or impairments that would affect your ability to answer my questions? Do you understand?
No, ma'am.
Okay. All right. And can you just state your full name for me? You have the right to remain silent and not answer any questions. Do you understand?
Yes, ma'am.
Any statements you make must be freely and voluntarily given. Do you understand?
Yes, ma'am.
All right. You have the right to the presence and representation of a lawyer of your choice before you make any statements during any questioning. You understand?
Yes, ma'am.
If you cannot afford a lawyer, you are entitled to the presence and representation of a court-appointed lawyer before you make any statements during any questioning. Do you understand?
Yes, ma'am.
If at any time during this interview you do not want to answer my questions, you are privileged to remain silent. You understand?
Yes, ma'am.
All right. I can make no promises or threats to induce you to make any statements. This must be on your own free will. Do you understand?
Yes, ma'am.
Any statements you make can and will be used against you in a court of law. Do you understand?
Yes, ma'am.
All right. Do you understand all these rights?
Yes, ma'am.
All right, and with those rights in mind, do you agree to speak with me?
Yes, ma'am.
Okay. So you obviously know what's going on, right? With your employer, Walmart. Can you tell me how long have you been working at Walmart?
Like, I would say a month and a week now.
Oh, just a month?
Yeah.
1 month? Okay. Did you work before that?
Yeah.
Where did you
Not
work?
really. I was in the army.
You were in the Army? Okay, well, thank you for your service. I appreciate that. How old are you?
I'm 18.
18? Okay, so you weren't in the Army very long? Didn't work out?
No, I was 17 when I joined.
Okay. Are you from here?
No,
Where are you from?
I'm from Jamaica.
Jamaica. How long have you been in the States?
Less than a year.
Less than a year? Wow. Okay, well, obviously we were called by Walmart for a theft investigation. Okay, you were made aware of that investigation today, right?
Yeah,
Okay, so this here is the statement you gave Walmart, correct?
correct.
Okay, so I briefly read over it. It says you have been kind of going through it at home, is that right?
Yeah.
Have nowhere to stay, have no car,
Yeah.
and that's kind of why you started doing what you were doing?
Yeah.
How much do you think, were you stealing every day when you went into work? No,
Not even
not every day. How many shifts were you working a week?
a week. I got 2 days off every week, so
5 days?
5
Okay. So out of those 5 days, how often do you think you were taking cash or making gift cards?
How often do I think I was taking cash?
Yeah, was it every shift?
No.
No. Just as you needed it?
Like when I see it's free. Like when no one's there, like.
Gotcha. Okay. When you had the opportunity?
Yeah.
Okay. And how much do you think you stole in cash?
In total, like in cash or in gift card? Are you
Cash.
talking?
In cash.
In cash, like 4,000 or 4,500 max.
Okay. And the gift cards was another?
Yeah, the gift card is like 4,000 or 4,000. Like in total for both, the max is like 8 or 9,000.
And you use that to buy a car?
Yeah.
And the car's not running very good, huh?
No, I bought a used card, so and then the gift card, I used the gift card to buy like parts for it so I could fix it right away.
Have you ever been in trouble before?
No,
Did you have kids or anything? No kids? Are you still living at home or were you living in the car or
I was living on the couch
on the couch? At your dad's house or a friend's house? Or
at my dad's house.
your dad's house? But you couldn't stay there or what's the deal?
No, the deal is like, because he heard I'm getting out of the army and that was the main thing, he wanted to like use me, like, so you know he got benefits and all that.
Uh-huh.
So now I got out and then he's telling me to do some things for my career that I don't want to do. And then because I said I don't want to do it, he's like I'm disrespecting him and all that. And then he was like, if I don't want to listen, I should leave. And he gave me an eviction paper saying I got 6 months to leave his house, but now I got 4 months. Next month is gonna be 3 months.
I mean, you got out of the army, you got a job at Walmart. What is your plan? Do you have a plan?
Do I have a plan?
Yeah, like what does your dad want you to do that you don't want to do?
No, he wanted me to join. He's in the sheriff's department, he's in the police, but I don't want to do those type of job. Yeah, he doesn't ask me what I want to do or nothing like that. He want me to do what he want me to do.
Right.
At first, I didn't want to join the army. The only reason I did, like, because so I could help my mom. Because then the army got benefit.
Right. Yeah, it would kind of help you out.
Yeah.
Had anyone ever confronted you about this while you were working there, or you had no idea that they knew?
I kind of have an idea that they knew.
You had an idea?
Yeah.
Okay.
I knew it was wrong. But,
So you said you knew it was wrong?
I knew it was wrong, but I knew it was wrong, but I never had a choice, I guess.
Yeah. I mean, you always have a choice, but unfortunately when you're kind of going through hard times, it makes you make not good choices.
Decision.
Yeah, because realistically, you taking this $8,000 didn't get you ahead, right?
He got me right here.
Right. And I mean, something tells me you know you want to work hard, right? Your intention is to get a car to get you to work, right? I mean, it says, I heard you say today that you had to take a Lyft to work, but then you literally wrote here that you tried to get a car so that you didn't have to take a Lyft or Uber to work.
Yeah.
But, I mean, where do you used to live in?
Yeah.
Is that the city, West Palm?
Yeah. That's his house. That's all that. Yeah.
Well, I mean, is there anything else you think that we should know regarding this incident? I can't really, I mean, you kind of wrote it all out for us, why you did what you did, so do you think there's anything else that we should know? Or you want to have any questions for me?
Like, what do you want to know? Like,
No, I mean, well, typically I would ask you why you stole, but I can see why you stole. Yeah, because you don't want to be homeless, you have to you need a mode of transportation. But you said what you did was wrong. I mean, there's really not much else to it, unfortunately. It's kind of a bad situation all the way around. You have any questions for me?
Yeah, like what will happen next?
So I think you are getting charged with the grand theft, I think, for obviously the dollar amount. I'm not sure if there are any other charges, because I'm just helping my partner out. So I will have him come in here and just let you know what you're going to be charged with. And then you're going to be taken down to the county jail and booked in for those charges. You've never been arrested, so you probably will get a bond. Bond?
Yeah.
So bond is like, they post an amount and you can put up 10% of that to get out of jail until your court date. Does that make sense? So you'll get bond with a court date. So if you can make the bond, you can get out until your court date. Does that make sense?
So typically, like, when would be the court date?
I think they're usually like within a month. But you've never been arrested though, so you might get released without a bond. I'm really not certain because I don't know what your charges are. Like sometimes you can get released on your own recognizance, whatever the case may be. You don't have any open cases or anything like that you have to worry about. So I'll have him come in here and explain all that to you though. Okay? All right, he's working on his paperwork. I'm gonna get your property all bagged up so that'll all go with you. So that way when you get out, you have that with you. Besides your necklaces, do you have any jewelry on?
No, sir.
All right, I'm gonna have to take those off you, okay?
Oh, I'm so sorry.
No bracelets, rings, nothing like that?
No.
Okay. All right. I'm gonna be right out here, okay? If you need anything, you can yell, okay?
Let's examine the constitutional framework. PBSO case number 24-073287. The subject: an 18-year-old Walmart employee identified as Carlos. Before any questioning, Detective Schultz administered a Miranda warning, the constitutional requirement established in Miranda v. Arizona, 1966. The Fifth Amendment protects individuals from compelled self-incrimination. Miranda requires 4 advisements before any custodial interrogation begins. 1. The right to remain silent. 2. That any statement can and will be used against the suspect in court. 3. The right to have an attorney present before and during questioning. 4. The right to appointed counsel, if the suspect cannot afford one. Detective Schultz went further advising Carlos that he could stop answering questions at any time during the interview. This additional advisement, while not strictly required by Miranda, strengthens the voluntariness of the waiver and limits suppression arguments. Carlos acknowledged each right individually and agreed to speak. Under Bergwis v. Tompkins, decided by the Supreme Court in 2010, a suspect who is advised of Miranda rights does not invoke them, and then voluntarily responds to questioning has made a valid implied waiver. Carlos's explicit verbal agreement to speak goes beyond implied waiver. This is a knowing, voluntary, and intelligent waiver on the record. Detective Schultz also confirmed, on camera, that Carlos speaks English, is not under the influence of any substances, and has no mental impairments. These pre-interview confirmations serve a constitutional function. They establish the factual foundation for voluntariness under the totality of circumstances test. The Supreme Court in Colorado v. Connelly, 1986, held that Coercion by law enforcement, not personal hardship, is required to render a confession involuntary. Carlos's difficult living situation, housing instability, recent army separation, financial pressure, does not constitute police coercion under Connelly. His confession is constitutionally voluntary. Any suppression motion on Fifth Amendment grounds would face significant precedential obstacles. Now, the substantive charge. Carlos admitted to stealing approximately $4,000 to $4,500 in cash and approximately $4,000 in gift cards for a total of $8,000 to $9,000. Under Florida Statute Section 8:12.014, grand theft in the third degree occurs when the value of stolen property is blanktation, $750 or more, but less than $20,000. This is a felony in the third degree. The statutory maximum under Florida Statute, Section 775.082, is 5 years in state prison, 5 years of probation, and a $5,000 fine. Carlos's admitted amount, $8,000 to $9,000, clears the felony threshold by more than 10 times. The charge is supported by overwhelming evidence. The method of theft, scanning items twice and issuing fraudulent returns, also implicates Florida Statute Section 812.015, retail theft by an employee. Critically, Carlos had already provided a written statement to Walmart loss prevention before police contact. That statement was obtained without Miranda warnings because it was not a custodial interrogation. An employee questioned by an employer's loss prevention team is not in custody within the meaning of Miranda. This prior written statement constitutes independent evidence, separate from and unaffected by the constitutional requirements governing police interrogation. It provided detectives with a factual roadmap before the formal interview began, and Carlos's custodial confession corroborated it in full. The prosecution therefore had two legally independent confessions, one pre-custodial, one post-Miranda. The evidentiary case was airtight. Now the outcome. Carlos was charged with felony grand theft and sentenced to 2 years of probation plus $8,500 in restitution to Walmart. No jail time was imposed. Under Florida's sentencing guidelines, a first-time felony offender with no prior record qualifies for a downward departure in sentencing. Carlos's full cooperation, voluntary confession, and acknowledgement of wrongdoing are mitigating factors courts routinely weigh in favor of non-custodial sentences. The restitution order, $8,500, reflects the actual loss sustained by Walmart, consistent with Florida Statute Section 775.089. Now the grades. Her Miranda advisement was complete, individually acknowledged, and supplemented with the right to stop questioning exceeding the minimum constitutional requirement. Her rapport-based interview technique produced a full, voluntary confession without any coercive conduct that could support a suppression motion. The single deduction. She speculated on the record about probable bond conditions and release on recognizance information outside her authority to commit to. While well-intentioned, statements about likely outcomes could, in closer cases, be construed as implied, promises a recognized basis for challenging voluntariness. Carlos receives a B. This conduct almost certainly influenced the sentencing outcome in his favor. Courts reward accountability demonstrated before and during proceedings. However, Carlos waived his right to counsel and spoke without an attorney present. This was legally permissible but not legally optimal. Counsel could have engaged in pre-interview negotiations, potentially limiting the scope of the confession or structuring a plea before full disclosure. The favorable sentence he received may reflect what competent defense counsel would have obtained anyway, but that outcome was not guaranteed without representation. PBSO and the state attorney's office receive an A. The sentencing outcome reflects proportionate exercise of prosecutorial discretion, balancing accountability, victim restitution, and the circumstances of a first-time offender. Key lessons from this case. Second, a pre-custodial statement to a private employer is not subject to Miranda. Law enforcement can and will use it. Employees have no Fifth Amendment protection against employer questioning. Third, cooperation has real sentencing value. Courts distinguish between defendants who accept responsibility early and those who force the state to prove every element. Fourth, the right to counsel exists precisely for moments like this. Invoking it is not an admission of guilt. It is the exercise of a constitutional right designed to ensure fairness in an inherently unequal process. Let us know if there is an interaction or legal topic you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out our second channel, Audit the Court, for more police interaction and courtroom content.